Welcome to another episode of the Napa Legal Weekly Podcast. I'm Mary Margaret Bush, Napa Legal's Executive Director, and I'm joined for this special episode by Luke Goodrich, who is Vice President and Senior Counsel at Becket, where he represents religious organizations and individuals and religious liberty disputes in courts across the country. Luke is also the award-winning author of Free to Believe, The Battle Over Religious Liberty in America. Since joining Becket in 2008, Luke has argued and won precedent-setting cases in the 3rd, 5th, 7th, 8th, 9th, and 11th circuits, so seems to have a preference for odd-numbered circuits, including the landmark decision protecting housing allowances for ministers. He also was counsel in Little Sisters of the Poor versus Burwell, Burwell versus Hobby Lobby, Holt versus Hobbs, and Hosanna Tabor versus EEOC. He's called by the Associated Press a top religious freedom attorney. And a particular fact that I'm very proud of, he graduated from Wheaton College and the University of Chicago Law School. So very happy to see my hometown represented so well in the religious freedom battle, Luke.
Thanks, Mary Margaret. Thanks for having me.
Of course, we're very excited to have you with us to talk about both the Apache Stronghold case in particular, but it's how it relates to religious liberty more broadly and where we are kind of in the religious liberty movement right now. Our team recently highlighted your team's work on the Apache Stronghold case in one of our weekly updates, and I would love to just set the stage for our conversation by asking you to tell us a little bit about your story as it relates to that case. What's your understanding of the facts, and what do you think are the legal principles that are at the core of the dispute in the Apache Stronghold case?
Sure. So the Apache Stronghold case is brought by a group of Western Apache Native Americans called Apache Stronghold, and it centers on a long-standing sacred site in modern-day Arizona, outside of Superior, Arizona, called Oak Flat. Oak Flat is the center of Western Apache religious existence. It's a direct corridor to the Creator. It's a unique dwelling place of what the Apaches call Gan, which are spiritual beings, kind of roughly equivalent to angels in Judeo-Christian religions. And for over 1,000 years, since before European contact, Western Apaches have gone to Oak Flat, and they still to this day perform religious ceremonies that are tied to the land at Oak Flat that can't take place anywhere else. Oak Flat is on the National Register of Historic Places. It's been protected for over 70 years. Nobody disputes that this is a sacred Apache site. A few years ago, however, a large copper deposit was discovered around 7,000 feet beneath Oak Flat. And some foreign-owned, Chinese-owned mining companies have been spending a number of years trying to obtain ownership of Oak Flat, and then they plan to mine it. They're going to tunnel underneath Oak Flat, blast at the ore with explosives, remove it, and the surface of Oak Flat will collapse into a massive crater around 2 miles across and over 1,000 feet deep. Oak Flat will just be gone, completely obliterated. The Apaches can never go there again. They can never worship there again, and their religious practices will be gone forever. And so that's what the federal government is planning to do with Oak Flat. And Apache Stronghold has sued. The Becket Fund is representing them, and they're alleging that this violates religious freedom to blast their sacred site to oblivion and end their religious practices forever.
I remember reading in your briefs under the substantial burden element in the religious freedom restoration argument that it's just about the biggest substantial burden conceivable to have your entire site of worship destroyed.
Yeah, so you mentioned the Religious Freedom Restoration Act. So that kind of gets to the laws at the center of the case. And the main law that we're relying on is a federal civil rights law. It's called the Religious Freedom Restoration Act. It was passed in 1993, right after the Supreme Court had interpreted the free exercise clause of the Constitution, interpreted it very narrowly, ruled against Native Americans who wanted to use peyote as a religious sacrament. And there was this huge bipartisan response to that ruling, culminating in the Religious Freedom Restoration Act. It was passed unanimously in the House, 97-3 in the Senate, signed into law by President Bill Clinton, had support of both left and right. And what the Religious Freedom Restoration Act does is it provides very broad protection for religious exercise. It applies to all federal law, all federal government actions, and it says that the federal government cannot, quote, substantially burden religious exercise unless the government demonstrates that imposing that burden on religious exercise is the least restrictive means of furthering a compelling governmental interest, which is kind of a mouthful way of saying it has to be the only way for the government to accomplish some really, really important interest is to burden religious exercise. So that's the statute that we're invoking in the Apache Stronghold case. And we think the first half of that statute is just straightforward. Is this a substantial burden on religious exercise? Does the federal government taking land away from Native Americans, blasting their sacred site to oblivion, and ending their religious practices forever, does that substantially burden their religious exercise? Of course it does. And then, under the statute, the burden would then shift to the government, and they would have the burden, it's a very high standard of showing that blasting the Apache sacred site to oblivion is the only way to accomplish some really, really important governmental interest. But the way the case has unfolded so far, the government has staked its entire defense on the first half of the Religious Freedom Restoration Act, the substantial burden question. And they argue, actually, substantial burden, it doesn't really mean what you think it means. It's a technical term. It's tied to old cases from the Supreme Court before, and in fact, it just doesn't apply to the government's use of land and the government's internal operations. So if the government is using its land or if it's doing something internal to the government, no matter what the government does, even if it stops your religious exercise entirely, it's not a substantial burden on your religious exercise. And unfortunately, the government got the Ninth Circuit to adopt that position in a narrow 6-5 en banc ruling. And that's what we have appealed to the U.S. Supreme Court and said, look, you gotta take this case. They got the statute wrong. They're conflicting with other circuits, and really Apache religious existence hangs in the balance, and we need you to take this case.
It's so interesting to see how this case is playing out, especially to just contrast what the argument that the government is making to justify the taking with almost the common sense dynamics at play. You have this Native American worship site. It seems almost like common sense. Of course, the government can't take over that without violating religious freedom. Um, so you mentioned the term burden a couple of times, both substantial burden and a little bit on burden shifting. For the non-lawyers in our audience, can you draw that out a little bit and talk about, what is the burden the Apaches must demonstrate, and what is the burden and how does that shift to the government? Can you talk a little bit procedurally about how that works for the non-lawyer?
Well, sure. When you have a lawsuit under the Religious Freedom Restoration Act, it usually proceeds in two parts. First, the plaintiff, the person bringing the case, has to show that the government is doing something that burdens, hinders, makes their religious exercise more difficult. And it's not meant to be a high bar. And when the plaintiff shows that, then the burden of proof, the kind of obligation to show something to the court, it shifts to the government. And the government has to show that imposing that burden on religious exercise is the only way to accomplish an exceedingly important governmental interest. So that's kind of how the statute works. And then, contextually, like if you zoom out on, what is a substantial burden on religious exercise, a lot of cases, typically, the government is, doing things like often it's imposing penalties on religious exercise. So you think back to like, some of you may have heard of like the Little Sisters of the Poor case, where the government imposed a contraception mandate and said, hey, nuns, you need to use your insurance plans to cover abortion causing drugs and contraception. And if you don't, we will fine you millions of dollars. So often there's like a financial penalty involved. And the courts often say like, hey, the government is putting this person to a choice. It's putting the religious believer to a choice. They can either adhere to their religious beliefs and pay a penalty, or they can give up their religious beliefs and not be penalized. And in our case, we're saying, look, here the Apaches don't even have a choice. It's not like the government is just fencing off Oak Flat and putting up no trespassing signs and saying if you exercise your religion here, we'll fine you or potentially imprison you. Like the Apaches don't even have it that good. They're not fencing off Oak Flat. They're swallowing it in a crater and just making it impossible to ever again exercise your religion there. And ironically, the government in this case it admits that if it put no trespassing signs up and fine the Apaches for trespassing, yes, that's a substantial burden on their religious exercise. But they maintain somehow that blasting it to oblivion is not, even though they can never worship there again.
It's really fascinating to see how the Religious Freedom Restoration Act comes into play as protection in these situations. And I almost, as you're describing it, kind of shudder to think what options would a faith group like the Apaches have in the absence of this, pre 1993. You alluded to the Little Sisters of the Poor case, and I know you were involved in some other cases like Hobby Lobby that also invoked RFRA. Can you continue a little bit that story of RFRA? You mentioned it was passed in 1993. Can you talk a little bit about just how that has evolved and brought us to where we are today with religious freedom law and the particular protections of that statute?
Sure. RFRA's been one of the most successful civil rights laws in recent memory. And back in 1990, when the Supreme Court drastically cut back on the free exercise clause of the Constitution, it did so in a Native American case. It was Native Americans who wanted to use peyote as a religious sacrament. And in response, it was really bipartisan reaction to that decision. You had, People for the American Way and the United States Conference of Catholic Bishops, all coming together and saying, this is wrong. We need to protect religious exercise. And so they passed this very broad, intentionally very broad federal law, applies to all other federal laws. Supreme Court has called it a super statute, in that it applies to all federal laws. And the basic concept is like we can't always predict when a government action is going to burden religious exercise. There's so many different religious faiths in the country, and the government regulates so many different areas of human life. We can't always know in advance where the conflicts are going to arise. So we pass this broad statute to make sure, to guarantee as a society that when the government is doing something that significantly hinders religious practices, it doesn't do that. It can't do that unless it has a really strong justification for doing so. And over the last 30 years, RFRA has protected everybody. It's protected, we've had cases for Sikh soldiers who want to grow a beard in the military, and the military was trying to make them shave in violation of their religious practices. It's protected, Native American feather dancers whose feathers were confiscated by the United States Fish and Wildlife Service. And it's protected groups like the Little Sisters of the Poor and Hobby Lobby, Christian groups, where the government's trying to force them to participate in and give out abortion-causing drugs and contraception in violation of their faith. And RFRA has just proven the test of time that it really does protect all faiths. And that's what we're asking the Supreme Court to do here is make sure it doesn't leave Native Americans out in the cold.
It's a really powerful story, religious freedom in America, and particularly how certain core principles have helped us navigate the different ways that society has changed or national consensus around particular issues has changed. It's inspiring to see how these timeless principles can provide clarity and sometimes difficult or even polarizing times. And I want to continue to draw on that story and incorporate here just a reference to the book you wrote recently, Free to Believe. I know you published that a couple years ago, and I would love to hear a little bit of the story of what what motivated you to write that book, and what story would you like to tell people who might not encounter religious liberty litigation every day, but still very much hold dear these principles that are being defended in the cases you mentioned?
Mhm. Yeah, I wrote Free to Believe specifically for non-lawyers, especially, I think anybody can read it and appreciate it, but I think Christian audiences in particular I had in mind. just to help the ordinary person in the pew understand what is religious freedom, why does it matter, how is it threatened today, and what can we do to defend it? Because I think the challenges for religious freedom today are not necessarily the same as they were 10 years ago, 20 years ago, 30 years ago. And Christians in particular face a new sort of hostility to some of our core beliefs around life and around marriage, around human sexuality. And we're facing pressures that we haven't faced before. So, Free to Believe is designed to kind of unpack what are the main threats to religious freedom today, and how can we defend our freedom, and what can we do about it practically as Christians. And I think, maybe one message from the book that I think is helpful in a case like Apache Stronghold, and it's, why should we care about religious freedom for people that we disagree with? I don't share the faith of my Apache clients, but why should a Christian care about religious freedom for people of other faiths? And I look at a number of different arguments, but consider two. So one, I point out that we often have an argument just rooted in self-interest in protecting religious freedom for people of other faiths. And that's the idea that, our religious freedoms of all different faith groups are tied together in practical ways. And so, if the government rules that, if the Supreme Court or the lower courts rule that the government can completely destroy a Native American sacred site, and that it's not even a burden on their religious practices, that's a threat to people of all faiths. I mean, just looking at federal land, I mean, a couple days after the Ninth Circuit ruled against us in the Apache Stronghold case, the National Park Service told the Knights of Columbus, a Catholic group, that you can no longer hold a Memorial Day Mass in a national cemetery, something they had done for decades without any problem, any dispute. And they cited the Apache Stronghold case. They said, this is federal land. This national park is federal land. We can do what we want with federal land. It doesn't burden your religious exercise. So you can't hold a Memorial Day Mass here, even though you've done it for decades. And so there's a very real sense in which our religious freedom of different groups are all tied together. And particularly if the rationale of Apache Stronghold is that anything that constitutes the government's internal affairs doesn't burden your religious exercise. I mean, that was the same argument made in Hobby Lobby and Little Sisters of the Poor, that this contraception mandate is just the government's internal affairs. So if courts buy that, everybody's religious freedom is threatened. And so, the book talks a bit about how purely as a matter of self-interest, we should care about religious liberty for our neighbor. But I don't think that's the best reason for caring about religious freedom for people of other faiths. I think the better reason is that religious freedom is a fundamental human right rooted in who we are as human beings, and it's a basic issue of justice. You see this in Catholic teaching and Dignitatis Humanae. You see it in Protestant teaching, Baptist Faith and Mission. Many of the early reformers recognize that human beings are born with a thirst for the transcendent, for the true, the good, and the beautiful, and for a connection with our Creator, for a relationship with God. And we can only act on that religious impulse in accordance with our conscience if we do so freely. Not You can't coerce someone into right relationship with God. And so when the government forces human beings to go against their conscience and interferes with their ability to relate to the Creator freely, it is violating a fundamental human right. And that doesn't matter what your faith tradition is. And so, just as a matter of justice, as a matter of fundamental human dignity, we should uphold religious freedom for people of all faiths, including people that we disagree with. And that's obviously at stake in the Apache Stronghold case, where Apache religious existence as we know it will cease if the government destroys Oak Flat.
It's so beautiful to hear you tell that story and really speak to not only why religious freedom matters in this case, but why it matters in general as a matter of justice. And I think you spoke to something that is really important in the religious freedom movement and in just in the public square more broadly, I think lately there's been some dialogue that, oh, real religious freedom only protects certain groups, or religious freedom isn't for everyone. And I think particularly as there's an increasing percentage of the population that does not identify as a person of faith or a religious person. I think you've really explained why, even for someone who's not a person of faith, or at this season not a religious believer, you've explained why these cases should matter to them and why this cause should matter to them as well.
Yeah, I would say even I mean, if for someone who's not a person of faith, it's definitely an extra step to want to care about religious freedom when that's not a big part of your life. But there are important arguments for even for people who have no faith at all to want to protect religious freedom. One of them is that really comes out of the founding era, the idea um, that religious freedom shows that there is something higher than the state, that our rights don't come from the state, they're not a gift from the state. There's something higher than the state. We are endowed by our creator with certain inalienable rights. Even if you don't worship a creator or subscribe to a particular creed, the fact that there's something higher than the government that's where the source of your rights serves as a powerful check on government. And by contrast, in a case like this Apache Stronghold, if the government can say, yes, we know that Oak Flat is sacred, that you've worshipped there for 1,000 years, that you still worship there today, and that your religious existence will be entirely obliterated if we mine there, but we don't care. We're going to do it anyways because we value economic development over your dignity and over your religion. I mean, that's a recipe for a government that has no limits. The government can do that to the Apaches. I mean, the government can do just about anything to anyone. And so, marking the bounds of religious freedom is an important check on the power of government, and anybody, religious or not, should care about that.
That's so well put. As your point, this is the Apache Stronghold offers a particularly poignant example because it's not really a great look to have Native Americans being forced off their sacred sites. Can you, you mentioned a little bit earlier um, that in your book you explore some of the threats that you see to religious freedom in the country. What would you say are the greatest threats to religious freedom right now in the United States, and particularly in recent years?
I do think one threat is just um, the the reduced importance of religion in the everyday lives of many Americans. I do think that that tends to dampen general enthusiasm for religious freedom. One of the other threats I identify, particularly for Christians, kind of a more novel threat that we haven't faced 20 or 30 years ago, is the fact that basic Christian beliefs about life, when life begins, and basic Christian beliefs about marriage and human sexuality are no longer broadly shared. And not only are they not broadly shared, they're often viewed as a threat to progress. And so we're seeing a lot of conflicts around pro-life issues. A lot of there are efforts right now. California is suing Catholic hospitals, saying they have to be willing to provide abortions. We saw this in Little Sisters of the Poor and Hobby Lobby with the contraception and abortion mandate in those cases. We have a case pending in the Supreme Court right now where the state of New York is trying to force Catholic and other Christian ministries to cover late-term abortions in their insurance plans, contrary to their religious faith. So you see that on pro-life issues, and obviously on human sexuality, and now on gender identity. There's a case in the Supreme Court right now on the question of whether professional counselors are allowed to help children embrace their biological sex and their body as a gift from God, or whether that can be banned. We've had cases on behalf of Catholic hospitals that didn't want to participate in gender transitions. And under the Obama administration and the Biden administration, the government was trying to force them to do that. So these are things that these are the types of conflicts that were unimaginable 20 or 30 years ago. And it's very important for Christians to be aware of these, to be willing to stand up for what they believe, and to try to litigate these effectively in court.
Well, that segues perfectly into my last question for you, which is we've talked about the threats to religious freedom. What do you think are the greatest opportunities for solutions? And I wanted to ask particularly your thoughts on that question, not only in the legal space, but also kind of in the public more broadly. How can we help people better value and understand religious freedom?
Yeah, my book, Free to Believe, I say very clearly, it's not a book of gloom and doom. It's really a book about hope. And we have a lot of reason for hope when it comes to religious freedom. I mean, there are a number of practical reasons. I mean, if you just look at America, our country, our system of laws, our Supreme Court, I mean, religion is on a decades-long winning streak at the U.S. Supreme Court. I think there have been 24 cases over the last decade. 23 out of 24 have been victories for religious freedom. We have a Supreme Court right now that's probably as supportive of religious freedom as we've ever had in the nation's history. And so, as a litigator, I look at that and say, we want to get cases that can go up to the Supreme Court, so the Supreme Court can set good precedent that will protect believers of all faiths for many generations. But also, as Christians, our hope is not ultimately in the legal system, the outcome of this or that election or this or that Supreme Court case. We have a hope that's rooted in Jesus Christ and the fact that he has conquered. He said, "In this world you will have trouble, but take heart, I have overcome the world." And in my book, I talk about, our calling is not necessarily just to win religious freedom cases or win in the court of public opinion. Our calling is to bear witness to the victory that Jesus has already won. And we can do that in many, many practical ways by loving our neighbors, loving our enemies, praying for those who persecute us, laying down our lives for our friends, remembering those who are in prison as if we were in prison with them. Scripture just has so much to say to Christians who are living in the midst of a hostile culture. But really, it comes down to loving God and loving our neighbor, being faithful to our everyday calling, and living out our faith publicly. Because the way we got religious freedom in this country was people who came here wanting to exercise their faith freely, Quakers and others who lived their faith even when they were persecuted here. Many of the best laws we have come from people who were willing to suffer for their faith. So if we're willing to live out our faith in public, willing to be faithful to the calling of God on our lives, that is ultimately what is going to secure religious liberty over the long term in this country, and that's great reason for hope.
Thank you so much, Luke. That's such an inspiring note to end on, and I'm very grateful that we had the opportunity to share your insights, both on the legal side of things, but also on religious liberty and our calling as believers more broadly. So it's been such a privilege to speak with you. Thank you so much for all that you do to protect religious freedom for everyone everywhere. Where can our listeners go to learn more about your work and just follow more your journey defending religious freedom?
Yes, you can follow our work at becketfund.org. We have updates about all our cases. You can also find my book, Free to Believe, anywhere books are sold, Amazon, other places like that. And just thank you so much for having me on the podcast. Thank you for everything that Napa does for religious freedom. And thank you for everyone who's tuning in. There's a lot of work we can all do together. So thank you.
It's been a privilege. Thank you, Luke, and thanks to all of you who joined us for this conversation.